Welcome, everybody. We'll get started here in just a few minutes. Just letting everybody into the Zoom room. Okay, let's get started. I'm Shannon Monnat, the Lerner Chair for Public Health Promotion, Director of the Center for Policy Research, and Professor of Sociology in the Maxwell School of Citizenship and Public Affairs at Syracuse University. Welcome to the first in what we hope will be a series of What's at Stake panels that cover timely policy issues that have far-reaching consequences. Before we begin, I'd like to acknowledge with respect the Onondaga Nation, firekeepers of the Haudenosaunee, the indigenous people on whose ancestral lands Syracuse University now stands. I'd also like to thank the extraordinary staff in the Center for Policy Research who coordinated the logistics for today, Emily Minow, Peg Austin, and Katrina Fiacci. Thank you as well to Tom Fazio, who handled the tech, and to the Maxwell Dean's Office for spreading the word about the event. Today, we're joined by a panel of faculty experts who will discuss the implications of the recent Supreme Court ruling in Dobbs v. Jackson, in which the court held that the Constitution of the United States does not confer a right to abortion and overruled both Roe v. Wade and Planned Parenthood v. Casey. Panelists will discuss how we got here, how the decision may affect access to abortion and other reproductive services, impacts to economic and health outcomes, implications of the decision on voting behaviors in upcoming elections, and what the decision could mean for the Supreme Court going forward. Our panel today includes 5 faculty experts from the Maxwell School. Dr. Thomas Keck is the Michael O. Sawyer Chair of Constitutional Law and Politics and Professor of Political Science. Professor Keck's research focuses on constitutional courts and the use of legal strategies by contemporary political movements. Dr. Carol Faulkner is Associate Dean for Academic Affairs, a 10th decade faculty scholar, and Professor of History. She studies the history of the 19th century United States with a particular focus on women, gender, sexuality, and social movements. Dr. Sarah Hamersma is Associate Professor and PhD Director in the Department of Public Administration and International Affairs. Her research focuses on health and economic implications of social policies in the United States. Dr. Jenn Jackson is Assistant Professor of Political Science. They also hold faculty affiliations in African American Studies, Women and Gender Studies, and LGBT Studies. Dr. Jackson's research focuses on gender and sexuality, political behavior, and social movements. Finally, Dr. Shana Kushner Gadarian is the Merle Goldberg Fabian Professor of Excellence in Citizenship and Critical Thinking and Professor and Chair in the Political Science Department. Dr. Gadarian specializes in US politics, political psychology, public opinion, and political communication. Each panelist will spend about 5 minutes discussing the decision from their specific area of expertise. We'll then have a discussion among the panelists on various questions of interest related to the decision. Attendees can enter their questions in the Q&A box, and we'll try to get to as many as we can. To kick us off, Dr. Keck, could you provide a brief summary of the Dobbs v. Jackson decision and talk a bit about how we got from Roe and Casey to this decision?
Thanks, Shannon, and thanks to everybody for joining us today. Roe versus Wade had been the law of the land for 49 years, and now it's not, which is a really quite striking change in constitutional law with only a handful of parallels in the court's history. So to get our conversation started, I wanted to just make 4 quick points regarding first the tone of Justice Alito's opinion for the court in the recent Dobbs decision, second, his approach to identifying constitutional rights, and then third, some likely implications of the opinion for abortion access, and fourth, some likely implications for the court's role in our political system. So in 5 minutes, so let me jump right in. So I would describe the tone of Alito's opinion as angry, impatient, and one-sided. He describes Roe versus Wade as, quote, egregiously wrong, which in my book is a pretty ill-tempered way to characterize a decision that has been supported by 2/3 of the justices who've served on the court since 1973, including fully half of all Republican appointees to the court, not to mention 2/3 of the American people. Now, there's a lot to criticize in Justice Blackmun's Roe versus Wade opinion, and the court's subsequent holdings did a better job of explaining why abortion rights were constitutionally protected. But all of those cases, from Roe v. Wade forward, tried to grapple with two countervailing considerations: the life or potential life of the fetus on the one hand, and pregnant people's right to control their own bodies and their own reproductive lives on the other. Alito's opinion in Dobbs gives exactly zero weight to the latter consideration. No matter if the pregnancy results from rape or incest, no matter if the fetus is non-viable, no matter if carrying the term threatens the pregnant person's life, in none of those circumstances does the Constitution impose any limits on the state's power to coerce people to bear a child, on Justice Alito's recent account. Now, Alito reaches this conclusion because he adopts a rigidly historical approach to the scope of constitutional rights. As he tells it, if a right is not explicitly protected in the literal words of the constitutional text, and if the authors and ratifiers of those words didn't think of that right as implicitly protected, then the right does not exist. This approach leads Alito to rely on some perhaps sketchy or discordant sources to modern ears. For example, multiple citations to 17th century English judge Matthew Hale, who did indeed write an influential legal treatise suggesting that some abortions should be criminalized, but is also known for sentencing 2 women to hang for witchcraft and for famously adopting rules of evidence in rape trials that persisted well into the 20th century and made it all but impossible for women to prove they had been raped. Now, Professor Faulkner is going to say more about Alito's use of history, but for the moment, let me just emphasize that the logic of Alito's approach is that if your constitutional rights weren't protected in the 17th and 18th centuries, then your constitutional rights aren't protected now. This probably goes without saying, but this rule has very bad implications for the equal citizenship of women and people of color. Now, let me say a quick word about abortion access in a post-Roe v. Wade world. And this is just a brand new situation that, we're not sure how everything's going to play out. But we can anticipate, I think, that the post-Roe v. Wade world will be like the pre-Roe v. Wade world in some respects. Before 1973, some pregnant people with the means to travel were still able to access safe and legal reproductive health care, and the burden fell disproportionately on poor women and people of color. But this new world will be different in some ways too. Compared to 1973, we are living in a very different world with regard to economic inequality, with regard to the expansion of the carceral state, with regard to electronic surveillance, with regard to the scope and power of the anti-abortion movement. So for these reasons and more, I think we can anticipate that the regime of anti-abortion regulation is going to be much more aggressive than it was prior to 1973. That's something we can talk more about in Q&A. Finally, one final point is that the court has not just overturned Roe, right? If you've been reading headlines in recent weeks, you know that the Supreme Court has executed sharp and aggressive changes in the law regarding gun rights, separation of church and state, government authority to regulate the climate and public health, voting rights, and more. This is a pretty remarkable run of decisions from the Supreme Court. It's not the first such period in the court's history. In fact, there's been a recurring pattern in which a once powerful political coalition, having lost the support of popular majorities, resorts to increasingly desperate measures to impose its agenda with only minority support. Judicial policymaking is an attractive vehicle for doing so, since the justices are heavily insulated from the popular will. If the court's history is any guide, the only way out of this cycle has been in the past and may again be in the future, some form of a reform of the Supreme Court, institutional reform of the court. Thank you.
Thank you, Dr. Keck. You're talking about a lot of very rapid change in a short period of time, and a little bit about the role of history here. And staying on that topic about history, Dr. Faulkner, for a large chunk of US history, before Roe v. Wade, abortion was not illegal. Could you tell us a bit about the rise of the first criminal abortion statutes in the US? Why did they emerge the way they did, and how did abortion rights evolve over time?
Thanks, Shannon. Those questions are actually central to the Dobbs decision. And so in my 5 minutes, I want to cover two topics. First, consider the history under dispute in the Dobbs decision. Is there a right to an abortion rooted in American history and tradition, and does it matter? In order to establish abortion as a constitutional right, even though it's not explicitly mentioned, Roe versus Wade relied in part on history, and historical arguments inform the response from Jackson Women's Health as well. The Dobbs majority decision rejects those historical arguments in favor of a literal reading of the 14th Amendment, as Tom just explained. And second, I'll briefly summarize the history of criminal abortion in the US before Roe. So first, the history at issue in the case. Is there a right to an abortion in American history and tradition? Historians in the United States, represented by two large professional organizations, the American Historical Association and the Organization of American Historians, submitted an amicus brief on the history of abortion in the Dobbs v. Jackson case. Their goal was twofold. First, to show that in the early US, the states widely adopted English common law, which only criminalized abortion after quickening, or when the woman could feel fetal movement, approximately 4 to 5 months. Second, when criminal abortion statutes emerged in the mid-19th century, approximately 1850 on, these statutes were not motivated by concern for the fetus, but the concern that white Protestant women were not having as many children, and the country would soon be overtaken by the children of Catholic immigrants. The historians focus in part on the man who led the campaign to criminalize abortion in the mid-19th century, Horatio Storer, a medical doctor who was closely involved with the newly formed American Medical Association, founded in 1847. Storer believed that women were defined by their wombs and that marriage and motherhood were women's highest calling. Further, as I mentioned, he worried about declining birth rates among white Protestant women. The historians point out that such biased arguments in favor of criminal abortion statutes are constitutionally impermissible. In the majority opinion, Justice Alito dismisses this history as very weak and instead cites a Seoul law professor's history and amicus brief versus the 15,000 plus historians. More importantly, Alito argues that even though states followed the common law and did not criminalize abortion before quickening, this did not necessarily mean Americans believed in a right to an abortion, and he argues that such a right was not imagined by the 14th Amendment. He further states that there is no evidence to suggest that Americans believe states shouldn't legislate against it, and of course they did. In the dissent, Justices Sotomayor, Kagan, and Breyer point out the historical dangers of Alito's interpretation of the 14th Amendment. No women at the time voted for the 14th Amendment. They did not have the right to vote, and less than a handful of lawmakers at the time viewed women as free and equal citizens of the United States. Indeed, in the post-Civil War period, when voting rights activists argued that women had been enfranchised by the protections given to them as citizens by the 14th and 15th Amendments, the Supreme Court quickly rejected their claim. And as Tom mentioned, the majority opinion ultimately sidesteps the issue of women's equality by defining abortion solely as a medical issue. And now for my quick but broad overview of the history of criminal abortion as understood by historians. As I mentioned, from before the American Revolution, Americans left decisions about the early stages of pregnancy to women. The earliest criminal abortion statutes emerged in the mid-19th century in response to sensational media attention to women dying from botched abortions. The concern then was not so much for the fetus, but for the health of women and the implication that their need for abortion was due to the prevalence of sexual immorality and sexual danger. Indeed, these statutes emerged in conjunction with a larger suppression of all speech and action around sexuality, the so-called Comstock laws, which a number of the Supreme Court's decisions in the 1960s and 1970s strove to undo. Of course, even when abortion was criminalized, Americans still sought the procedure. And as some of my colleagues will discuss further, outlawing abortion in practice meant that Americans had unequal access to the procedure. Further, states and localities had almost no way of enforcing these laws unless a woman died from an unsafe procedure. Importantly, most of these criminal statutes included an exception for the health and life of the mother. By the mid-20th century, as obstetrics as a field advanced, hospitals established therapeutic abortion committees. If a woman needed an abortion, she would have to plead her case to a panel of doctors. But because of the intrusiveness of the hospital boards, as well as the very real threat of sterilization, especially for women of color, many women chose illegal abortions rather than trying to qualify for a therapeutic abortion. And in many ways, the inconsistency of the decisions by doctors and hospitals paved the way for the movement to legalize abortion. Criminalizing abortion endangered women's health by making doctors their judges rather than their healers. And it was ultimately in part health concerns that turned most doctors and Americans in favor of abortions. And I'm happy to talk more about that in the Q&A. Thanks so much.
Thank you, Dr. Faulkner. So with that history in mind, let's move to what's going on right now. And to provide some context, I'm showing a map that displays the current legal status of abortion by state. The red states here are those where abortion is already banned. The peach are where bans or severe restrictions are expected soon. The green are states where abortion is legal. And you can see that about half of US states are expected to either ban abortion or impose heavy restrictions following the Supreme Court's decision. One of the implications of this decision is that our states are now in effect like 50 different countries when it comes to how abortion rights are handled, with rights intact through New England, the Northern Atlantic states, and the West, but very limited throughout the South. So I want to turn to Dr. Hamersma and ask about what we know currently about the prevalence of abortion in the US, and how could this decision affect access? But in addition to that, what does the research say about the role of other factors, such as economic security and social safety nets on pregnancy and abortion rates?
Thank you so much, Shannon. It's great to be included today. I'm an economist who works on anti-poverty programs with some research on the well-being of mothers and children. My most recent work finds that Medicaid access during pregnancy improves both birth outcomes and maternal mental health. And I also come to this conversation as someone who sees policy as one tool that we need to help meet mothers and children's needs and to prevent harm at all points in the child's life cycle. So I'm an empirical researcher, which means I think it's helpful in a discussion like this to start with some baseline statistics. And then I'll talk about the research on some of the likely consequences of Roe being overturned and where I think we need to direct some of our attention. I'd like to talk about a few kinds of baselines: abortion prevalence, abortion opinions, and reasons for abortion, but just very briefly. So where are we at? In the US, the abortion hit a peak in abortions around 1990. And it's been on a slow long-term decline until 2017 when it began rising again. Recent years typically in the US have about just under 4 million births and just under 1 million abortions. The pattern for many years has been that just under half of pregnancies are unwanted, just under half of those are aborted. Abortion pills now account for over 50% of abortions and rising. So that's kind of the state of where we are. Shana will talk more about public opinion, so I'll just make one point of interest. A majority of Americans think that there ought to be at least some limitations on abortion, and a majority of Americans oppose outright abortion bans. It is rarer to support either unrestricted access or total bans. Some recent qualitative work provides a bit of nuance for this, concluding that many people don't have well-developed views, many feel conflicted, and many don't feel they can discuss this issue safely among the people they know. I'm glad for the chance to do so today. As far as reasons, in survey data from the Guttmacher Institute on reasons for abortion, maternal or fetal health reasons were given as the main reason for pursuing abortion about 7% of the time. By far, the most common reasons are financial and personal constraints. We might think of some of these as social constraints, or at least policy sensitive constraints, such as employment, educational, and financial consequences of childbearing in a society that devalues caregivers. So with this context in mind, let me move to describe a bit of what researchers in my field of health economics have found regarding the implications of Roe being overturned. So first, there's the question of the number of abortions. Economist Caitlin Knowles-Myers has done excellent work investigating this, and I checked with her yesterday to make sure my discussion of her work is accurate. She starts with estimates developed in some of her co-authored work that used Texas abortion clinic closures from some years ago to estimate how distance to an abortion clinic affects the probability of getting an abortion. And she uses this distance sensitivity estimate alongside the map that Shannon just showed us to estimate the nationwide change in abortion rates. And she finds that nationwide abortions will fall by about 13%, 1-3. This is about 100,000 fewer abortions in the next year, with about 75,000 surviving pregnancy and becoming newborns, which will add to the 3.7 million births we already anticipate in the coming year. People on all sides of the abortion debate are often surprised by her estimate that this change isn't larger. So let me provide a bit of context first. Although the overall change is small, for some geographic areas, it will be larger. Women in these areas will see substantial drops in any sort of drivable access, even outside their own states in some cases. Second, some of the states committed to the widest access to abortions are those with the highest abortion rates. So for example, New York and California make up about 18% of the US population, but 30% of abortions happen there. These asymmetries mean that geography is key. We also can't project far into the future, as Tom mentioned. Some of the factors are changes in clinic capacity, mail order abortion pill access, and possible changes in contraception use. Beyond the number of abortions, there are the effects of abortion access on other outcomes. Some studies look at particular state level policies. One prominent one called the Turnaway study surveyed women seeking abortions who were either barely eligible or barely ineligible for one based on their week of pregnancy and their state's regulations. That study is focused on later term abortions. Most of the fetuses in the sample were past 21 weeks gestation, which is the top 1 percentile of abortion age. The majority of women in a quarter of the women in this study were actually beyond 24 weeks, which is recognized as the age of viability. The bulk of the evidence from these studies suggests there are educational and economic advantages to abortion access, at least in these samples. And this indicates completed education, poverty status, financial security improvements. As with all health economics research on abortion, fetal outcomes are not addressed in these studies. Though the key authors of the Turnaway study note that the account, quote, the account we have presented of women who seek later abortions is not meant to supersede consideration of the fetus in the abortion debate. This leaves the door open for further conversation about how to understand the results of these studies in terms of policy implications, particularly post-viability. And I just want to emphasize that I think we need to focus even more emphatically on the work that we can do through prenatal WIC, SNAP, Medicaid, and other supports, through parental leave, through better medical care at birth and more equitable medical care at birth, and to use policy to reduce harms to mothers and fetuses. I don't pretend this will be politically easy, but I hope that we can have a great discussion about it. Thanks.
Thank you, Dr. Hamersma. There certainly are a lot of considerations here. Very complex issue with a lot of causes and consequences. Dr. Jackson, Dr. Hamersma just mentioned that abortions may decrease by about 13% based on some recent research. But it seems like we know from other research that these bans will have greater consequences for some groups than others in terms of different demographic groups, geographic groups. How might we think about this decision from within the broader context of reproductive health justice and who has access?
Absolutely. Thank you so much for organizing this conversation, Shannon. Thank you all for being here. I'm going to really focus on thinking about specifically who will be deeply affected by this decision. And I'll move through not too many data points. I think we've covered a lot of data so far, but I want to talk about some specific parts of this decision that will affect Black working class, poor communities, and folks who have already been disproportionately affected by the restrictions on abortion access so far. So first, I want to start with a conversation just around Black maternal health and the fact that Black birthing people are 3 times more likely to die from pregnancy-related complications when compared to white birthing folks. And that's folks who, whether they would like to bring that pregnancy to full term or not. So the current conditions in our Western medical structure are such that if you are Black and you enter the hospital and are giving birth, you are already disproportionately at risk of not surviving that process. What's also important to note is that when we think about abortion access and we think about who will be most impacted, folks who have less access to healthcare and reliable healthcare, folks who are working class and poor, but also incarcerated people. So something we don't talk about a lot is when we talk about the fact that there are no protections here for folks who are victims of rape and incest. We frequently are thinking about, people who are not incarcerated, but we should also be thinking about folks who are in prisons. Those folks who are currently incarcerated are already struggling to get access to abortion in a Roe world. Having to take long trips to go and get procedures, having to negotiate with prison authorities and guards to ask them, will you drive me somewhere for 2 hours so I can get an abortion while incarcerated? These things are now going to be even more complicated and even less likely to happen for those people who find themselves dealing with an unwanted pregnancy behind bars. This can be even more detrimental to folks who are in this situation because we know that time matters here. So the longer that they are forced to have this compulsory pregnancy, the less time they have to abort that pregnancy in a way that does not put them at risk. So that's another community that we have to think about. And I want to kind of connect this larger conversation back to the 14th Amendment, right? When we think about the 14th Amendment and the idea of equal protection and due process, that's a Reconstruction Amendment. The Reconstruction Amendments 13, 14, and 15 were meant to solidify the idea and codify the idea that Black folk were no longer property, but they were people. And Roe is an extension. It comes directly from this idea of personal liberty that comes from the 14th Amendment. And so when we think about the history and the connectedness this decision has to our deep history of racial enslavement and the long arc of slavery in this country, we have to also consider the fact that this is not without intention and not without design. When we think about the communities who are most impacted by this decision, we have to think strategically and explicitly about the root here, which is thinking about the idea of states' rights and its rootedness in the ways that folks were once property here. So I want to come back to that, and I know that we'll probably talk about that in the question and answer, but I want to end my comments thinking about eugenics in this country and the kind of closing statement from Justice Sotomayor and Justice Kagan. We know that up until the 1970s, Black, Brown, Indigenous women were forcibly sterilized in this country, across the country, and more prominently in the South. It's no surprise that the states that we just saw on that map are some of the very same states where we saw that forced sterilization of Black, Brown, and Indigenous women. And what Justices Sotomayor and Kagan said in their dissenting opinion was simply that this was not about justice, this was not about liberty, but this was about having the numbers on the bench. This was about politics. This was about pushing a conservative ideal, and that is not even in alignment with the precedents that we have set before us. So I want to, end there and simply just to say that we have to always think about the roots here and the long history that we have that affects particular communities, not by accident, but by design.
Thank you, Dr. Jackson. And thinking about these mortality impacts, the potential health impacts, I think a lot of the attention has been on the anticipated increase in unsafe abortions outside of the clinical context. But what you point out is that the mortality burden of abortion bans includes additional types of pregnancy-related mortality, given that childbirth in the US comes with a lot of risks. So women who are giving birth die of infection and sepsis, cardiomyopathy, hemorrhage, many other causes. And the US has an especially high rate of maternal mortality compared to our peer countries. There are some estimates that under the scenario of a total abortion ban in the US, pregnancy-related deaths would increase 7% in the first year alone and 21% in subsequent years. And to your point about racial disparities, people who are racialized as Black would experience the greatest increase in deaths of 33%. So that's pretty striking. I want to move to opinion polls because we talked a bit in the beginning about attitudes and what Americans think about abortion. And so Dr. Gadarian, opinion polls show that a majority of Americans support some type of abortion rights. Prior to the ruling, 60 to 70% of Americans polled said that they didn't want Roe overturned. And for context, the right to obtain a legal abortion is even more popular than same-sex marriage was when the Supreme Court struck down state bans on same-sex marriage in 2015. But of course, sentiment varies across states, as we can see from this graphic on the right. And given that states are now in the driver's seat on abortion rights, voters in some red states like Louisiana and Utah are likely to see their state policies come in line with anti-abortion majorities. But there are other states where a clear majority of residents support abortion rights, but where the state legislator is likely to ban it, including Arizona, Georgia, Michigan, Wisconsin. Analysis by political scientists at your field suggests that after this decision and the law, it triggers 14 million fewer Americans will live under their preferred abortion policy than they do now. So as a result, a lot of pundits on the radio and television news are saying that this decision could have major impacts on midterm election outcomes. But what does the evidence tell us about how much decisions like this actually affect political behavior and outcomes? Are there enough competitive Senate or House seats up for grabs for this decision to sway the outcome? How do voters get mobilized around these kinds of issues?
Great, thanks for the questions. And so I'm going to start with the caveat that I give to everyone about public opinion polls on issues around policy is that most people know little about politics most of the time. Okay, so I'm not going to talk very much about specific policy issues. I am going to talk, but people have values, right? So that's the kind of counter to this, which is most people don't know a lot about specific cases. I think the Supreme Court decision about Dobbs v. Jackson is probably the most extreme in terms of people knowing about it and having an opinion. Most people know even less about the Supreme Court than they know about other policy issues. But that doesn't mean that they don't have meaningful values that they can bring to evaluate what they want out of government. But what I'm not going to do is talk about specific support for any particular kinds of restrictions that we might see at the state level. So things like whether or not there should be waiting periods or counseling as part of restrictions that states might bring to abortion access. I'm going to talk kind of in broad terms about what we know about public opinion on the issue of abortion, which is nuanced, but I'm going to talk kind of in broad terms, and then I'll talk about how we might think this matters for the midterms. So the kind of little soundbite part is public opinion in the aggregate has majority support for legal abortion. The public is open to restrictions, but the kind of full of abortion bans that we're seeing in states like Ohio that we are likely to see in other states have minority support. These attitudes have been steady over time, but that aggregate support for legal abortion, there is divergence by party, as you saw in the graph that you showed. Okay, so over time, Democrats have moved to be more supportive of legal access and broad access, whereas Republicans have grown to be less supportive than they were at the time of Roe. We can talk about why that happened. But I just want to give you a sense of the kinds of questions that get asked about abortion access. I think the best set of questions that we know of over time that we can compare is from the General Social Survey, which is run by sociologists, and has asked a series of questions about access to abortion. It asks about women and whether women should be able to obtain legal abortions for any number of reasons that go from, and they ask about 6 reasons, whether she's single and can't afford it, she's poor, there's fetal defects. And what we see over time is that 40%, about between 35 and 40% of respondents in the GSS support all 6 reasons that are given. And there's variation, but about 25% of people fall on the end of the scale where they don't support legal access for almost any reason. So while we see that there is nuance here, the majority of people, and then everyone else kind of falls into, yes, there should be legal access for some reasons, but not for others. So what we see is that there is majority support for legal access, where there are people who are less supportive on reasons that seem like they're more discretionary, okay? If you add other questions, if you ask about morality, people have their own sense of whether abortion is moral or not, but that actually doesn't necessarily lead to them wanting to ban it for other people. So if you add other questions about whether or not you would help with an abortion if someone you know needs one, again, we see even people who kind of are supportive of abortion rights for all people under all circumstances, not everyone will say that they would help, right? So there's kind of variation, with the majority falling into, I think there should be legal access, but not everyone who is on the pro-choice end being as willing to help themselves or help another person with abortion access itself. Okay, I'm at 4 minutes. Yikes. All right, sorry. I'm going to talk about 2 other issues. One is that at the time of the Roe decision, the parties were growing apart ideologically, and we see this also with abortion opinion. So while the parties themselves looked pretty similar on abortion policy in the 1970s, they're very different now in terms of the kinds of policies that they support at this point, and you see that in the public. So when you see people say things like conservative women, when they see what will happen under a post-Roe world, will change and become Democrats and be supportive of abortion rights, don't take that very seriously, because partisan identity is so much a part of the way that people understand abortion policy that their identity as women will not overcome that. Okay. And in terms of midterms, and I'd be happy to talk more about this, people need to understand what's happening. So it's up to candidates to talk about what's happening at the state level. And while we see national opinion being supportive of pro-choice policies, at the state level, there is variation. But what we're seeing is a move toward more restrictions, even in places where there's publics that are supportive of abortion rights. And that is because of the way the states themselves are gerrymandered, and many of the state legislators are insulated from accountability and being pushed out of office because of their positions on issues like abortion. So the place to watch is actually not just in the midterms about whether or not angry people will come out and turn out in the midterms at the national level, but really at the state level races for governors in states with mixed legislators are likely to be very consequential for access going forward. States like Wisconsin, Kansas, Pennsylvania, North Carolina, these are places to keep your eye on.
Thank you. Great job, everybody. So much interesting information and a lot to dig through here. While we're on this topic of public opinion, Dr. Gadarian, you just mentioned that the majority of Americans support some sort of abortion rights. Likewise, most Americans support some sort of gun regulation, but the Supreme Court also just overturned a century-old law in New York State that restricted concealed carry. So Dr. Gadarian, or actually anyone on the panel, how much should the Supreme Court consider public sentiment in their decision?
I I think I'm going to let Tom answer this. I can tell you what happens when the public how the public evaluates the court based on their decisions. But I think I'm going to let Tom answer the question of how much the court should think about public opinion.
Sure, thanks. I'll jump in on that. So, I mean, that's fundamentally an ideological, political, normative question, and everyone's going to have their own answers to it. But I will say this, that the political science literature on the history of the court and its role in the broader American political system shows a pretty clear general pattern, which is that most of the time, the court operates within the broad mainstream of public opinion, right? So not every single case, not every single day, right? But that most of its major politically consequential decisions fall within the acceptable bounds of the American public's views, but that there are recurring exceptions, right? So that there are exceptional periods in the court's history where, due to the cycles of partisan alignment and realignment, the court winds up out of step with the rest of the political system. So just to give one quick example, in the 1930s, during the Great Depression, FDR and the Democratic Congress repeatedly passed new laws to try to address the Great Depression: minimum wage laws, maximum hours laws, laws governing working conditions, laws governing labor relations, Social Security, and the like. And the Supreme Court over and over and over again struck those laws down, right, during FDR's first term. And that court was wildly at odds, right, with American public opinion. Repeatedly, the court invalidated laws regulating child labor, right? The vast majority of Americans thought the government should have the authority to regulate child labor, and the court repeatedly said it did not, right? Which eventually came to a head, right? The American public is only going to tolerate a court that is wildly at odds with public opinion for so long. And so we have seen recent public opinion polls come out even before the recent Dobbs decision, showing the court's public support at historic lows, right? And so that is something that the court is probably going to have to pay attention to sooner or later.
Thank you. We have a question in the Q&A that gets back to the history of abortion, and I also think speaks to the racialized nature of this decision. So for Dr. Faulkner and Dr. Jackson, what do we know about the history of abortion as at-home healthcare in early America and or among Indigenous people? Was the history cited in the opinion? Should it have been? And what sorts of connections could we draw between that history and what we're dealing with now?
Yeah, great question, Jen. I'll go first and then you. Is that all right? So one of the ways we might think about these criminal abortion statutes is it is a power play by medical doctors who are newly professionalized and trained in taking power away from women and midwives and people who are practicing medicine but not formally trained as doctors. And so in the first decades of the 19th century, a woman could go to a pharmacy and apothecary and purchase medicines to restore her menses. This was considered a commonplace drug. Women could make it themselves. That, they were made up of common herbs. And so in this way, it was widely accessible. But part of the American Medical Association's long opposition to abortion was about taking control away from the home, from the family, and from people who are not formally trained medical practitioners.
So I guess I'll address the racialized component and also kind of the other part of the question about the dissenting opinion. I thought that Justice Sotomayor's and Kagan's dissenting opinion was really important because they really did tap into the history of protections in this country and the concerns facing minoritized people and poor folks in this country. So specifically thinking about what they said about the 14th Amendment, and I'm reading their opinion here, they talk about several instances where Roe was kind of ratified twice in our history, and where Roe and Casey were both applied in other precedents. And so one thing we have to understand, and I'm looking at Dr. Keck here because I am not the person who does courts, but I will say that we all do, I think, to some degree, understand precedent, right? And what's important here is that when we roll back the precedent in one instance, there's a whole kind of domino effect on other cases and other instances that could potentially put people at risk. And so what folks are concerned about here when we think about, young Black, brown folks, queer and trans people who already have a very fraught relationship with reproductive justice in this country, is that there's a lot of fear around what might happen to other protections that keep them safe, right? And so what the concern here, I think, is that people don't want to go back to a place where abortions and reproductive care are things that we do in the shadows, right? Because that again puts folks' lives at risk. There is a concern here about the facilities that folks may be wanting to go to, the Planned Parenthoods that have typically been surveilled and closed. Doctors who provide abortions are sometimes harassed, sometimes even killed, right? There's a lot of concern about the ways that will also limit not only the access to abortion, but to a whole host of other health services that these folks rely on. And so that is what they talked about in this opinion, the fact that when we ratified the 14th Amendment, women were not considered yet to be full human beings, full citizens. And as we continue to peel back these types of protections, we peel back those declarations that birthing people are full citizens who have a right to liberty and to choice over their bodies. And so the real concern here is that if we don't have these protections in place, then there won't be institutionalized structural methods and mechanisms in place to ensure that folks are safe and that they can go out and make an appointment for their care and know that they won't be arrested and that their doctor won't be criminalized. Like, these are the things that folks are concerned about.
Those are all really good points. And there's also been a lot of concern, and I see some questions about this in the Q&A about the precedent this sets and the implications it might have for other decisions. So, Dr. Keck, let's talk a bit about how this decision might affect the Supreme Court going forward. I mean, Justice Clarence Thomas wrote in his concurring opinion and suggested that other rights that weren't addressed by the framers of the Constitution, such as same-sex marriage and legal contraception, could be revisited by the court. And the liberal justices in their dissent warned that no one should be confident that this majority is done with its work. So how might this decision affect other constitutional rights?
Yeah, so it's a great question. There's extensive discussion of this point in the court's opinions. As you mentioned, the dissenters warn about the negative impact on other constitutional rights. Justice Thomas, in a concurring opinion, calls for further unraveling of additional constitutional rights. But Justice Alito, in his majority opinion, says the decision poses no threat to other constitutional rights, right? So this is clearly a point of contention. Now, here's the thing. Justice Alito's claim that the decision poses no threat to other constitutional rights, the ones most often mentioned are the right to use contraceptives and the right to marriage equality for same-sex couples. Alito says no threat to those other constitutional rights. The only way that can be true is if Justice Alito and the other justices in the majority do not themselves believe in the strictly historical approach to identifying constitutional rights that they have outlined in the opinion. Because if that is the approach to identifying constitutional rights, it clearly, right, the constitutional text does not protect your right to use contraceptives, and the authors of the 14th Amendment did not think that was an implicit part of what they were writing. So the same, and we know this, right? I mean, in the court's most recent marriage equality decisions, Alito dissented in all of them, and he wrote the same thing in those dissenting opinions that he just wrote in the majority opinion in Dobbs. So we know that the logic of the court's recent opinion threatens other constitutional rights as well, which does not mean that all of those other constitutional rights are now going to fall, because the court doesn't operate solely on the basis of legal logic, right? And so if the public pushback to Dobbs and if the public support for marriage equality and other constitutional rights is robust enough, then the court throughout its history has often pulled back, right? It outlines a particular view of the Constitution, but then it gets a lot of political pushback and it pulls back. So in terms of what is actually going to happen next, we don't know, right? And it will depend on the outcome of political events that are still unfolding. But in terms of the legal logic of the court's decision in Dobbs, it clearly poses a threat to other constitutional rights. And I'll just say, just to respond to one thing in the Q&A, someone asked about Loving versus Virginia, which is the court's decision striking down bans on interracial marriage. Justice Thomas did not mention that one in the list of decisions he called to be overruled. There is a plausible distinction, which is that Loving rested both on the right to marry and on the Constitution's prohibition of racial discrimination. And Justice Thomas does believe that the Constitution, the 14th Amendment Equal Protection Clause, prohibits racial discrimination. So that's a plausible distinction. Of course, there are equal protection arguments in support of reproductive rights, and there are equal protection arguments in support of LGBT rights as well. Thomas doesn't support those, right? Based on his originalist approach to the 14th Amendment, he thinks it applies to a very narrowly understood conception of racial equality. So Loving is not likely to be overturned. I don't think Obergefell is likely to be overturned either, but I do think there will be challenges to it, and this recent decision provides legal ammunition for those challenges.
In the few minutes that we have left, I'd like to spend it talking about where we go from here. So for people who are concerned about this decision, and this is for any of the panelists, how important will grassroots leadership be to raising awareness, to getting out the vote, to getting different people elected in state legislatures? And then in addition to that, even though the politics on this are really polarized, public opinion is a lot more nuanced, as we've heard, and public opinion varies a lot across states. Are there spaces for cooperation across groups where we could build trust toward common goals? So maybe I'll start with Dr. Hamersma, and then others can jump in.
Absolutely. Thank you, Shannon. I think we are in a really tough spot of polarization. And when we think about the root causes of demand for abortion, poverty, poor maternal health care, poor childcare opportunities, employers that would love to just hire male bodies, there are a lot of reasons that people feel like having a child is infeasible. And there's a lot of common ground between people with different views on when fetal life should be protected or not, who can agree that these are very problematic. And so I especially have found a lot of interest in some of the more recent progressive activists who are thinking about this as a broader human rights thing. And I think that there's a lot more common ground to be found between Democrats and pro-life progressives than maybe Democrats and traditional pro-lifers. And so I think that there's a movement within those who are concerned about fetal life to say, hey, the reason that we have not been able to handle the pregnancies in our country that we have is because we don't support caregiving, we don't support birthing, we don't do what we need to do to keep our families healthy, to keep our women healthy, to keep our children healthy. So there's a ton of nonprofit and public work to be done along those lines, and I hope that we'll do it together.
I'm going to try not to be the kind of Debbie Downer, but I kind of am, which is that for that to happen, right? No, I think on the grassroots level, that makes sense, that there is common ground on public policies that can make caregiving easier, that can make family formation easier, that can support poor single parents. What I don't see is those progressive policies happening in the states that are also banning abortion, right? Those are the same states that do not have policies that make caregiving easier. And there is no clear move in state legislatures that are banning abortion to also put in place anti-poverty programs. In fact, these are the same states that won't expand Medicaid. So I think that there is room for that, but it will not happen unless you change the political incentives for office holders at the state level. And that will be harder. And so as Jen talked about earlier, there are a lot of connected issues, and I don't want to say that they're all intractable, but the issue of voting rights and state legislatures and where we draw the lines of in state legislatures is key here. And it doesn't see, I think we might not think that these are connected, but the Supreme Court taking on issues around gerrymandering and who gets to draw the voting districts at the state level is really important here, because state legislatures that are insulated from public opinion are unlikely to move toward those kinds of policies that are broadly helpful for family formation. And until the kind of state legislatures feel that push, right, from broad coalitions, they're unlikely to change. So I think there is work to be done, but I'm not seeing it at the state level in places that are also banning abortion.
Can I jump in here? Thank you so much, Dr. Hamersma and Gadarian. I want to answer the specific part of the question about grassroots activism and organizing, and I'll share just a little bit from my own research and talking to young Black folks across the country since 2018. And overwhelmingly, when I talk to young Black folks who are thinking about parenting and starting families, I've talked to a lot of folks who have said, I no longer want to have children. I'm too afraid. I'm too scared to go into a hospital and give birth. I'm too afraid to start a family. I don't know what that would mean for my own health, but also for the health of this child. And so a lot of young Black folks across the gender spectrum have already been grappling with these questions and have been long organizing around reproductive justice and reproductive rights, voting rights, and such for generations. And so what I would encourage people who are thinking about the grassroots level is to think that, our politics have to be local. In these particular states that have been really targeting abortion rights, voting rights, these bathroom bills, all of these kind of pieces of legislation and policy that really hone in on the rights and protections of minoritized people who are already at the margins of multiple margins of identity. Folks have to get local, right? So don't drive over the state lines and go to Missouri or to Maryland or to, wherever you see the thing happening on the news. Get local and find out what's happening in your neighborhood, in your community where you pay taxes, and really start to dig deeply in the ways that you can change the environmental conditions and the political conditions facing people where you are. That's where you have the most power. And I really want folks to realize that the organizing is already happening. So find out what people are doing, get local, get active, and support the movements that have been working so hard on these issues, and that a lot of people have had the opportunity to ignore because it didn't affect them until now.
Excellent advice. And I think actually on that hopeful note, it's a good point to draw this to a close. I want to thank you all for being here. This was a really engaging conversation. I wish we had more time because there were so many questions we weren't able to get to. But again, I hope this is one of many ongoing conversations about pressing policy issues. I want to thank all of the attendees and wish you all a great day. Take care.